All right, members, let's bring this this meeting of the Civil Justice Full Committee into order. If we can go ahead and take the roll, please.
Representatives Bricken, Clemens, Curcio, Eldridge, Farmer, Garrett, Gillespie, Griffey, Harris, Littleton, Ogles, Parkinson, Ramsey, Smith, Stewart, Vice Chairman Jernigan, Chairman Carter. Mr. Chairman, you have a quorum.
All right, thank you so much. And members, Vice Chair Jernigan is presenting a bill in another committee, so once he gets back, we'll just take a brief recess and we'll let him take over. But in the meantime, does anyone have any personal orders, any announcements, anything they'd like to say or do before committee starts? All right, fair enough. Let's go ahead and get started. That brings us to item 1, House Bill 140. That's by Representative Ogles, I believe, is carrying that. Got a motion and a second, and you're properly recognized, sir. Is there any amendments traveling with this?
No, sir, not that I see on the bill.
Okay, and I do have Tori Grimes and Linda Klingman from Tennessee Department of Corrections. They're available if any member has any questions. We can go out of session and certainly take care of that. But other than that, the floor is yours, sir.
Thank you, Chairman, members of the committee. As many of you will recognize, this is a piece of legislation we saw last year. This is a Judge Carter bill that I'm happy to say that the TDOC and the administration has signed on to. So now it's an administration bill. But what this does is many times, regularly across the state, TDOC brings issues of conservatorship in probate court for people that are incarcerated in one of their facilities or one of the mental health facilities. Very limited effect to issues of mental capacity as far as illness. This is very limited in scope, and it only involves conservatorship. Right now, TCA and case law is very clear that you do not lose your primary domicile while in a facility. So therefore, they have to bring action in all 95 counties and sometimes even out of state. What this would allow is them to bring this action in the probate court in which a person is housed in a facility. And with that, I'll take any questions.
And thank you for the explanation. Members, have any questions or comments for Representative Ogles?
Question on the bill.
Question's been called on the bill. Is any objection? Seeing none, looks like we're ready to vote. Send House Bill 140 to calendar and rules. All those in favor say aye. Aye. Opposed say no. Ayes have it. Bill moves on.
Thank you, Chairman, members of the committee.
Thank you for that. Brings us to item 2, House Bill 326. Chairlady Moody.
Motion.
And you are properly recognized, ma'am, and I don't see that you have an amendment moving with this, so you are free to move forward.
Correct. And thank you very much, members and committee. I don't, you think about things you forget to mention, so I don't think I mentioned this in subcommittee, but this bill was something we ran last year, so there's nothing new. There's nothing new. It's just the same bill that we're going to run again since COVID got it last time. But the purpose of the bill, it will add aggravated statutory rape and statutory rape by an authority figure to the list of offenses for which the offender will be prohibited from having custody or inheritance rights with regard to a child born as a result of the offense, and for which any visitation will be conditioned on the other parent's waiver and request. And with that, I'll ask for a yes vote.
Very good, and thank you for that explanation. This is a great piece of legislation. Members, do we have any questions or comments for Chairlady Moody before we vote? Question's been called. Looks like we're ready to vote to send House Bill 326 to calendar and rules. All those in favor say aye. Aye. Opposed say no. Ayes have it. Bill moves on.
Thank you all.
And members, if we don't mind, without objection, we're going to take a quick recess and let, really a minute, maybe 30 seconds, let Vice Chair Jernigan get ready to take over. Thank you.
Okay, members, we're back in session. Next up is House Bill 25. Chairman Todd. Chairman, you're recognized.
Thank you, Mr. Chairman and committee. This bill creates a process for defendants to assert civil immunity that they already have, doesn't change their immunity, or they may request a stay of any civil proceedings related to a criminal proceedings until criminal proceedings have been concluded in a self-defense situation. We had this bill last year and fully vetted and passed, and I have worked with members on this committee. I've worked with Chairman Carter quite a bit on this, as well as another committee last year to make sure we got this crafted properly, and just affords people that already have immunity in our law the ability to have a stay put on that, on a proceeding, so that they don't have to fight two battles at the same time in the legal world, both criminal and civil.
All right, members, you've heard the explanation. We do have someone who's requested to speak, Jason Sparks from Moms Demand Action. So we're going to go out of session and listen from him. Mr. Sparks, you're recognized.
Thank you. I'm Jason Sparks. I'm a resident of Nashville. Good morning, and thank you for the opportunity to speak today. I'm here today to ask this committee to oppose House Bill 25, which would expand Tennessee's stand your ground law. 4 years ago, I lost my best friend of 36 years, my baby brother, Christopher Sparks. Even though he was 36, he had really just started life. He had spent most of his 20s working in restaurants and had recently gone back to college and gotten a degree in mathematics and physics. He moved to Nashville to be closer to us and gotten a great job with the Tennessee Department of Labor and Workforce Development in Metro Center. It was wonderful. He was there for every birthday party, soccer game, dance recital. He was always there for my kids, who were 7 and 5 at the time. We had a special relationship, and though we were different, we were best friends. On September 28th, Chris had taken his lunch break to drive to his home in the Nations to walk his rescue dog, Dawson. Along the way on Rosa Parks, he spoke to someone driving erratically. That person shot him at the next intersection, 2.5 miles from where we are right now, and drove off, leaving him to die alone in his car. To me, this bill is about the right of survivors to seek relief when they choose, which is a vital feature of our justice system. House Bill 25 is unnecessary because Tennessee law already provides immunity from civil liability for people who lawfully use force, including deadly force. This bill would allow the shooter to request that the victim or victim's family delay filing a lawsuit until the conclusion of a criminal investigation or prosecution. If the shooter does not request that the lawsuit be delayed and the victim files a lawsuit, the shooter can then request an immunity hearing to establish that they're immune from a civil suit. So, for example, the person that shot my brother could have claimed that they were just standing their ground and defending themselves and delay my family from ever getting any civil justice for years until the criminal prosecution was over. Delays, it would be re-victimizing the victims, essentially. So delays like this discourage gun violence survivors from taking those who unlawfully use force to civil court, blocking the right to timely relief at the time when they're most vulnerable. Why would Tennessee want to do this to its citizens who are victims of violence? Survivors know they'll never get their loved ones back. What we want is justice and the knowledge that the perpetrator will not harm someone else. And we want recompense for the pain and suffering, for the counseling for our children, for funeral costs that we weren't expecting or ready for. We can never return to what we had or to what we were, but we can move on. Without your help on this bill and others like it, we can't even do this in a timely fashion. It galls me to know that there are laws like this being proposed when it will make harder for my family and others to achieve justice when people are potentially irresponsible with their guns. That's
That's fine. Thank you, Mr. Sparks, and I'm sorry for your loss, and thank you for your testimony. Members, do we have any questions for the Chairman Farmer?
And thank you, Mr. Chairman, and thank you, Mr. Sparks, for being here. I know it takes courage and to share your story, your loss, and we are all extraordinarily sorry for your loss. Something that never should have happened. It's a tragedy. And also, I wanted to apologize to you personally. I think I overlooked you last week.
Thank
Certainly
you.
wasn't intentional.
I understand.
I chair the subcommittee, but I want you to know we're about transparency and making good policy here, and we'd never intentionally leave somebody off the list to speak. So I wanted you to know that, and my sincere condolences for your family.
Thank you, Chairman
We're
Farmer. I
praying for you.
appreciate it. Thank you.
Thank you, Chairman. Any more members? Seeing none, we'll go back into session. Chairman Todd, you're recognized.
Thank you, Mr. Chairman. And while I share the same condolences that have already been mentioned here for the Sparks family, and I've heard this testimony twice in the last couple of hours, and I do share their sincere pain in that. As he stated, defendants already have immunity in this state. This doesn't change that at all. This just simply gives a person the ability to put a stay on a civil proceeding until a criminal investigation takes place and is adjudicated. And as we all know, most of those are done very, very quickly, sometimes within hours, sometimes within days. But in the right situation where a defendant has used force to defend themselves, and we have that right to do right already, then they're not going to be fighting two legal fronts at the same time, which one could jeopardize the other. And that's all we're trying to do here, is to protect law-abiding citizens. The perpetrator that has been mentioned in testimony already was a criminal. There's nobody here that would defend that person for their actions. So we're not defending criminals here. We're defending law-abiding citizens. Thank you, Mr. Chairman.
Thank you. Members, you heard the explanation. Any questions? I think Clemens beat you to it there, Parkinson. Representative Clemens, you're recognized.
Thank you, Mr. Chairman. And Representative Todd, I just want to get clarification. This legislation would require the stay until the criminal action is completed. Is that correct?
Recognized.
Yes, sir, that is correct.
Okay, so I just want to get clarity. A second ago, you said this can happen in a day or a week or something along that timeline. I've never seen a criminal case for, let's say, a murder be resolved in a day or a week. So I just want to ask you to clarify that or get some clarification from that in case you misspoke or in case I misunderstood you.
Chairman.
Thank you.
Thank you, sir. And I'm certainly not an attorney. And, I see things that happen on TV. I see cases where someone defends themselves, and all I was referencing is some of those more simple situations where it's really obvious it's a self-defense situation, and there are no charges brought. So that's all I was really referring to. Obviously, there are cases that would apply to this and would have a significant longer time, could be months. And again, I'm not in that realm, so I don't really know how those tend to take, how long those tend to take or how they are processed. But I appreciate that clarification.
Yeah, well, thank you. I appreciate that. And oftentimes I wish that the legal process played out like it does on TV and as efficiently and as fast sometimes, but often that's not the case. So that's one of my concerns for this. So thank you for clarifying that. Thank you, Mr. Chairman.
Representative Parkinson.
Thank you, Mr. Chair, and thank you, Chairman Todd. I'm a little bit conflicted on this bill, and the reason why is because I agree with you that a civil case could possibly sway a criminal case, but I also where I part ways with you respectfully is in the assertion that or the assertion that these are law-abiding citizens. We won't know if they're law-abiding until after the case is over with, and they may be found innocent or may be found guilty, and then we will not have been under this legislation defending a law-abiding citizen. And so, but I get it, because even this, in regards to civil asset forfeiture, and I'm not trying to go down the rabbit hole, Mr. Chair, but I feel the same way about that. You taking property from someone before they had a chance to be heard in the courts. And so I just wanted to, just get out what was in my head to you. That's all, So, but thank you again, and thank you, Mr. Chair.
Chairman.
I would certainly agree to you, innocent until proven guilty. And so that's all this does. It protects those that are innocent. Certainly the criminals are going to be prosecuted, and then they will certainly be, that civil situation will be dealt with in another court.
Follow up, go ahead.
Thank you, Mr. Chair. Under this legislation, it wouldn't be an automatic stay, would it? Would a judge would still have to approve the stay, am I correct?
You have to request it, and then a judge would order that.
So, but does the bill say that the judge shall or may? How does that work?
Thank you, Mr. Chairman. I believe a judge shall, but it's under certain circumstances. You have to meet those actual circumstances in the law. So they're doing an assessment, I believe, of the immunity that the person already has under law, and then they would apply that stay.
Okay, but there's not really any discretion for the judge to make that decision. I'm sorry, and maybe you can explain what those factors are, if you don't mind. And I just want to get just a little bit more clarity.
Okay.
Chairman?
Yeah.
I'd be glad to. If a plaintiff files a civil action against a defendant based upon the same facts or events that the criminal situation, the defendant may assert in any responsive pleading or by motion in writing pursuant to the rules of civil procedure that, one, the defendant's use of force or threatened use of force was justified and permitted by existing law. The defendant has immunity from the civil action pursuant to the above described present law provisions. Because of the defendant's immunity, the claim does not state a cause or of action upon which relief can be granted, and the defendant requests an immunity hearing to determine if the civil action should be dismissed for reasons. So there is another avenue even for that. If the immunity hearing is requested or ordered, the court must expedite the hearing, hear the matter, and issue a decision within 40 days of the hearing being requested or ordered. From the time the hearing is ordered, all aspects of and procedures relating to the civil action will be stayed. All applicable parties must be given notice authorizing such parties to appear and present evidence at the hearing. And there's already provision in the rules of the court to preserve evidence. That was another concern we had, and it's been expressed before. And we wanted to make sure that no evidence would be lost, because we don't want anyone's rights infringed upon here. We want to make sure that everybody has their day in court and that their interests are protected. So that's already, fortunately, again, I'm not an attorney, but that's what our research has shown from all the documents and the other attorneys we've consulted on this and had involved in this.
So, Mr.
Representative Parks?
Thank you, and thank you for that. That gives me a little bit more clarification. So there is still some discretion in there in the judge making that decision based on if he feels that those criteria are met or not met. Am I correct?
Yes, sir, that is correct on dismissing the case. Yes, sir.
Thank you, Mr. Chair. Thank you, sir.
Representative Griffey, you're recognized.
Thank you, Mr. Chairman. Thank you, sponsor, for bringing this legislation. I fully support it. This legislation kind of tracks what the feds do normally. In federal court, if there's a civil action that's also got criminal charges, the courts typically, there's presumption it'll be stayed, and we'll deal with the civil side after the criminal matter is resolved. For the main purpose, you really don't want what the outcome of any civil stuff to impact someone getting a fair jury trial if there's criminal charges involved, because we're talking about somebody's possible imprisonment and so forth. So you want to make sure that's based solely on the law and the facts that are brought to the judge in that case. And this doesn't alter the universe other than it says things will be put on hold. So at some point, they're going to get justice on the civil side. We just need to let the criminal side go first. I think that's the smart approach, and I support this legislation. Thank you for bringing it. Thank you, Mr. Chairman.
Yes, sir. Well, I got one more. Representative Garrett, will you withdraw? Or the question's been called. Will you want to withdraw and let Garrett speak, or Rush? Okay, yeah. Representative Garrett.
Thank you, Mr. Chairman, and thank you, Representative Bricken, for that. I want to go over a situation where I had a client, and I want to make sure this is one of the intentions of your legislation, Chairman Todd. I fully support it, but I want to make sure that I understand that what happened to me, this would prevent my client from potentially violating or getting his Fifth Amendment rights violated. I represented a felon in divorce, represented the husband, and he was charged during the pending of this civil action for putting a GPS monitor on his wife's car. That's a misdemeanor. That's a crime. Can't do that. So the slick lawyer on the other side decides to try to take my client's deposition. And in that deposition, I bet you can probably guess the very first question of that deposition is, did you put this GPS monitor on this car? What does that do? boom, invokes the Fifth Amendment, because what are you going to do, say yes or no? And you've implicated yourself, which you're guaranteed not to do under the Fifth Amendment of the Constitution, right? So in that instance, if he said that and invoked his Fifth Amendment right, that implies something to put that into testimony, and then you can bet your bottom dollar that that civil testimony, the deposition, is then going to be used in the criminal matter to say, what did you say about that in your divorce case that had nothing to do with the criminal matter that's concurrently going on while his civil trial is going on? Some slick lawyer will use that against that to violate, unbeknownst to you potentially, your Fifth Amendment right. Is that the intent of what this bill is trying to protect? So in both matters, in both civil and criminal court, you are guaranteed a fair trial, which you are guaranteed under every constitution in the United States.
Chairman.
Absolutely, sir, and I appreciate you bringing in something that's similar. Obviously, it's not a self-defense situation, I don't think, from your description, unless I misunderstood, but it is the same principle, exactly. We do not want your expressing your rights in one case to potentially violate your rights in the other.
Thank you for that clarification, Mr. Chairman. Mr. Chairman, thank you.
Very good. Any other questions from members? Seeing none, we're going to be, question's been called. Without objection, we're going to be voting on sending House Bill 25 to calendar and rules. All those in favor say aye. Aye. Those opposed? No. The ayes have it. You'll be going to calendar and rules, sir. Item number 4, Representative Lamar. We have a motion and a second. Okay. Representative Lamar, we're on the bill as amended. The amended code is 3678. We adopted it last week. And so we're going to recognize your bill as amended, and you have the floor.
Thank you, Mr. Chairman. Good afternoon, committee. My bill, House Bill 340, is a bill that's written when a child is taken into custody due to suspicion that the child committed a delinquent act or unruly conduct. A law enforcement officer conducting a formal interview or interrogation of the child at law enforcement facility concerning any violation of state or federal law by the child should make an audio or video recording for the interview or interrogation. The officer is believed to be in good faith. The officers in good faith believe the interrogation or interview has been recorded, has technical issues or extrinsic circumstances will be outside of this. This bill I worked on with both TBI, law enforcement, and Sheriff's Association, and brought this bill back last year. We had some very lengthy debate. Hopefully I've been able to answer all you all questions individually. But that is an explanation of my bill, and thank you, Mr. Chairman.
Yes, thank you. And you're right. I think Department of Safety and TBI and Sheriff's Association all have signed off on it. Members, any questions on the bill? Representative Garrett.
Representative Lamar, thank you very much for bringing this legislation, and I want to thank you personally for taking the time to address my concerns today on the legislation. And just so to kind of reiterate those concerns we talked about last time, I kind of warned you I may ask this question.
Yes, sir.
And I wanted to make sure you were okay with this scenario. And my concerns last week were that in a law enforcement facility, obviously Miranda for a juvenile attaches. So I was a little bit concerned about a juvenile not being provided that Miranda, but you had clarified to me that if it is not, then that recording obviously is inadmissible, right. and you're okay with that. That's the way the law is, and we certainly don't want to violate any juveniles' rights as well. So is that your understanding?
Yes, sir. And
Okay.
Thank you for articulating that. And yes, sir, I agree with you.
Thank you very much. Great bill. I appreciate it. I'm going to support this bill. Thank you very much.
I appreciate you.
Representative Griffey.
Thank you very much, Mr. Chairman. Thank you, Representative Lamar, for bringing this legislation. I support it. I think it's good, smart legislation for Tennessee. Thank you.
Chairman Curcio.
Thank you, Mr. Chair. I was going to move previous question. But
The question's been.
I withdraw.
Yeah. I've got one more speaker, but it's up to you. Want to withdraw?
I'll withdraw.
Okay. It's been Representative Parkinson.
That's why me and Chairman Kersey are such close friends, man. Y'all, you know, we bonded, right? But I just wanted to tell my colleague, Representative Jarrett, that of course this is good legislation. It's coming from State Representative London Lamar. All right. Thank you, Mr. Chair. Sorry, I'm out of order.
Members, any more questions? Seeing none, we're going to be voting on House Bill 340 to go to Finance Sub. All those in favor say aye. Aye. Those opposed? Ayes have it.
Thank you so much, committee.
Yes, ma'am. Members, going to item number 5, House Bill 1137. Representative Grills, you do have a motion and a second. You have an amendment, sir? Yes, sir. We have a motion and a second on the amendment. I've got tracking code 4908. Okay, good deal. We've got a first and a second on your amendment, so you are recognized on the amendment, sir.
Thank you, Mr. Chairman and committee, and thank you all for all the hard work y'all do. Y'all spend a lot of hours on this committee. I've sat in a few of the subcommittees and these, and it's, y'all are here for a few more minutes than I am in some of the committees I get to serve on. That's right. Well, anyhow, what this legislation does, it pretty much prohibits the governor or the health department from being able to make a blanket statement or a blanket implication across the state that would shut down a church or in a view of another pandemic. I believe that a church is an important part of our life, and it's not only our physical life, but our spiritual life. Ultimately, I just want to make sure that the governor did not do this in this past pandemic, and I want to make sure that's understood. But we have seen in other states where governors have, I felt like they've overreached, and they have shut down with blanket policies, churches and the ability to come to worship. So with that, I'll take any questions from the committee, but I also have someone here who'd like to testify if that'd be possible.
I've got one representative that wants to speak. Gillespie, is that okay with? All right, thank you.
I can wait until.
Okay. One question. Does the amendment make the bill?
Well, thank you, Mr. Chairman. Last week in Chairman Farmer's committee, there was a little bit of a discrepancy or discussion with the governor's office about what this bill would do. Could it impact upward, like the basketball that are run at churches and whatnot? The goal was to make sure religious services were protected, not the extracurricular activities, potlucks and basketball and volleyball games at churches. So the amendment removed the word activities and pretty much just sum that up. So that was the goal.
Okay. Members, let's put the amendment on the bill, and then we'll go and discuss the bill once amended. So all those in favor of putting amendment 4908, amendment number 1 on the bill, please say aye. Aye. Those opposed, ayes have it. We're now on the bill as amended, and I think I'll start with Representative Gillespie. I think was. Yeah.
Thank you, Mr. Chairman. Thank you, Representative Grills, for bringing this. I've got a couple of worries and a couple of questions I just want to address. First of all, and maybe I'm misunderstanding this, but if it passes, it will give a blanket restriction from any health professional in a advisory capacity or elected capacity to not place restrictions on people gathering inside of a church during a service, whether it's a pandemic, epidemic. Is that incorrect, or can you?
Yeah, that is incorrect. This is strictly for a pandemic or emergency situation. If you'll look, I believe it goes to Title 58 with the Emergency Powers Act, and that's where we're trying to take that power away from the governor's office, the executive branch.
So just because I'm still a little confused here, so bear with me, I'm sorry. So it would, under emergency declaration, no longer allow someone that is, say, a biologist to make those decisions? Or that's where I'm confused there.
Representative.
Let's see, Section 1A, number 2, if you'll read that in the amendment there, or the bill, for the purpose of this subdivision, unsanitary does not mean free agents or infection. The closure of a public established facility or building, the county health officers or otherwise by law take that action. They still have the ability to shut something down if there is an infectious disease breakout. But as far as a blanket policy that the Department of Health or the governor lays out for the whole state, they cannot shut down every church just because there's a pandemic or an emergency. It's specific.
Next is Representative Parkinson.
Thank you, Mr. Chair, and thank you, Representative. My only concern, my only heartburn about the bill is, while I understand that the governor didn't do it this time, but I don't know if there will be a time where he may see it to be feasible to do it. And I just don't want to tie his hands, you know, in being able to make make the decision. I don't think he would make a decision like that, you know, to shut churches down across the state. I really don't. But if we don't know what kind of extreme emergency may come up where he would need to do that. And so that's my only misgivings about the bill is, you know, I just don't want to tie the hands of the governor. Now, is the administration supporting the bill? And maybe I might be missing something.
Yes, I have actually had this conversation with the governor to make sure that he recognizes this is not sticking my finger in his eye in any way, shape, form, or fashion, but recognizes the importance of having religious freedoms and the free exercise of religion. So with that, the governor's staff and I have worked on the amendment, and that's where we come to the agreement on the amendment. Callan had to leave to go to another appointment, but they are fine with it the way it is.
Representative.
And thank you for that, Representative. I don't know, were you about to say something else before I went? Okay. So the administration is supporting the bill? Is that what you're saying?
I did not say they were supporting it. They are comfortable with it.
Okay. So, okay. And I'm not trying to kill your bill. I don't even think I had the power to kill your bill, to be honest with you. But I do have concerns about, you know, about our executive not being able to make that decision, you know, if he needs to make the decision. You know, and you know, I'd maybe be more comfortable with it if it was something that some language that we added possibly that says, you know, the governor maybe in consultation with the speakers, both speakers maybe, you know, that way we're not tying the hand of if he needs it. And I never expect Governor Lee to do this, to shut down churches. And the last thing is this, is that, you know, you can shut down a building, but it doesn't mean that you shut down the church, right? Because the church is here anyway. And you know, and you can gather with family or whoever you want and have church, you know, anywhere. We have church in here. Not trying to kill your bill, just want you to understand where I'm coming from on it, okay? Okay, and that's thank you, Mr. Chair. And thank you, Representative.
Representative, I apologize to you. You had a speaker that you'd like to say a few words and testify?
That'd be okay.
Yeah, I almost pulled a farmer. That's what, let this guy out of here. But that's we want to make sure we recognize Mr. Aaron Snodderly. We're going to go out of session and to listen to Mr. Aaron Snodderly, I believe. I hope I pronounced that right, from the Tennessee Independent Baptist of Religious Liberty.
Yes, sir.
You're recognized.
Thank you, Mr. Chairman. My name is Aaron Snodderly, as you've said. I am the Executive Director of the Tennessee Independent Baptist for Religious Liberty, and we are an organization that was founded by some of Tennessee's finest pastors across the state of Tennessee for the purpose of promoting and protecting our religious freedom here in our state and around the country. As such, I stand before you this afternoon for the purpose of encouraging you to not only support but to vote for HB 1137. As we look over the last year, we've seen a pandemic that none of us expected or planned for, and we saw various responses to the pandemic, but some of the responses as Christians and people who cherish our First Amendment rights, we feel overstepped their bounds. And we look at states like California, New York, and we see churches, small and great in size, who were told that their churches had to be closed permanently until a governor told them it was okay or a health official told them it was okay to reopen. And they've been threatened with fines, they've been threatened with jail time. Even some pastors across the state have spent time in jail already simply because they wanted to do what the First Amendment gives them the right to do, and that is exercise their religious freedom. Now, we're thankful that in Tennessee, Governor Bill Lee has been a stalwart when it comes to defending our First Amendment rights, and we thank him for that. We thank you as a House and as a Senate, a state legislature, for defending our First Amendment rights. But we ask you to go a step further and help us guarantee that in the future, if something ever arises again, a governor could not make the same mistake that those governors in other states around the country have made this past year. And so we ask you to go a step further and protect the rights of churches to meet and worship God according to the dictates of their own conscience. We're very familiar with the First Amendment, but I would like to just read it quickly. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And I want you to notice it does not say unless there is a pandemic. Then it goes on to say, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble. And again, it does not say unless there is a pandemic. And then it says, and to petition the government for a redress of grievances. I believe that the right to freely exercise our religion is paramount, but in the case of this bill, I believe the clause of the First Amendment that says we have a right to peaceably assemble is most important, because churches do not meet to riot on the streets and burn our cities and towns. We meet to worship God. And so we believe that the First Amendment clearly identifies our right to freely exercise our religion and to do so in an assembly that we choose, whether at our church or at a park, wherever it might be. Now, it's interesting to note that the 14th Amendment actually says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. And so we believe that the 14th Amendment says that states have to abide by the First Amendment. Therefore, no governor should be allowed to force restrictions upon churches or people of faith, even during the time of a pandemic. Now, the Supreme Court agreed with this analysis because in 1937, in the case DeJong versus Oregon, the Supreme Court ruled unanimously that the right to peaceably assemble for lawful discussion, however unpopular or popular, cannot be made a crime. And they did so on the basis that the 14th Amendment's due process clause guarantees us the right to exercise our First Amendment rights. Even in the state of Tennessee, we have codified this by stating in the third section of Article 1 that all men have a natural and indefeasible right to worship Almighty God according to the dictates of their own conscience. And again, I'll add, it does not say unless there is a pandemic. And then it goes on later to say that no human authority can in any case whatever, in other words, even a governor or a health official, control or interfere with the rights of conscience, and that no preference shall ever be given by law to any religious establishment or mode of worship. And the key word at the end of the third section there is mode of worship. If a church chooses their mode of worship to be in an actual church building or at a park, even during the time of a pandemic, not only does our U.S. Constitution give us the right to worship God as we choose, but the Tennessee Constitution says no one, even a governor or health official, can limit our mode of worship. Last but not least, in Article 1, Section 23, the Tennessee Constitution also says that citizens have a right in a peaceable manner to assemble together for their common good, to instruct their representatives, and to apply to those invested with the powers of government for redress of grievances or other proper purposes by address of remonstrance. Clearly, we have a U.S. federal right to worship. We have a state constitutional right to worship. And we ask you to help us protect these rights in the future by making it very clear and obvious, even more so, that no government or health official can restrict these rights. Thank you, Mr. Chairman.
Thank you, Mr. Snodderly. Do we have any questions? Looks like we do. Representative Griffey, you're first.
Thank you very much, Mr. Chairman. Is it Reverend Snodderly or Mr. Snodderly?
You can call me Mr., that's fine.
Okay, Ms. Snodderly. Thank you for coming here and bringing here and sharing your thoughts on Tennessee's First Amendment, our constitutional rights. I deeply appreciate those. What I wanted to ask, are you aware, I believe under Tennessee law, the way we've set up for emergency situations, there's 4 jurisdictions because they have their own health-funded departments, that those jurisdictions are allowed through their county mayor, their top elected official, to issue orders concerning public safety or whatever.
Yes, sir.
Okay. Are you aware, in any of those counties, did those mayors issue any orders that prevented churches, anyone that wanted to meet to go to, were they allowed to go to church? Were they prevented from going to church during that time, this time period we've had?
I cannot speak for every situation, but it is my understanding that at the beginning of the pandemic, there were a few who tried and then came to the conclusion that was not the governor's will, and so they stepped back. So I'm not, again, aware of anything in the past we're so much concerned about as much as it is we're looking towards the future and trying to build a better, more perfect union.
And thank you, Mr. Chairman. I appreciate that, and I'm deeply troubled and concerned that our constitutional rights have been infringed upon. And this is not a criticism of Governor Lee. I think this is something that befalls on the General Assembly. We're the people's representatives, and we take people's constitutional rights away, their Fourth Amendment, the right to be free. We imprison people. But the way we do that is the people's elected representatives come up here and pass laws, and then we let the executive execute those laws that we do. We don't give the executive the authority to make up what the law is and then punish the person. That's a fundamental affront to our constitutional principles, and I hope that this General Assembly will take action as we go forward to reset the balance. There's certainly a time period for emergency action, but you know, we had a special session. We got up here in 7 days, gentlemen and ladies. So I submit that if there's an emergency, we ought to be able to get up here and meet within 7 days, 15 days, whatever it is. But we just don't need to keep going on and on and on. We are not serving our constituents' rights and asserting for them, and it's our duty to do so. So thank you very much. Thank you, Mr. Chairman.
Thank you.
Representative Harris?
Thank you, Chairman, and thank you so much for the sermon on that. I do want to mention that our Constitution can be changed, and currently, I believe that we elected a governor who does a fair job in making sure that he protects us in a fair manner, and so I don't think that we should be able to take that right away from him per se, and this also doesn't limit where a church necessarily is considered to be. And with that being said, I could want to have communion and get my bread and grape juice at McDonald's and call that my church and a place of worship if I would like to, and no one can hold me accountable to that. And so I think that there's probably some language changes that could be made to this. But I thank you again for your message with us.
Can I respond to him?
Sure, go ahead.
Okay. Yes, we 100% appreciate what our governor has done. I agree with you on that. Again, this is not about our current governor or really even past governors. It's about what could happen in the future. Now, you mentioned the opportunity for a governor to shut us down. And again, I believe that comes back to the mode of worship mentioned in Tennessee Constitution, Article 1, Section 23. It's not the government's place to determine the mode of worship, which would include where a church worships, when it comes to even the time of a pandemic. And so all we're wanting to do is clarify that, because people these days don't use their dictionaries to understand what that word means. So if we pass this law, it'll be much more clear, stating that governors and health officials do not have the right to shut down our churches, even during the time of a pandemic. So, but I appreciate your thoughts and your service.
Representative Harris?
Thank you, Chairman. So, do you feel more comfortable with the leaders of the actual church making those decisions rather than the actual governor?
I feel comfortable with religious freedom. And we say it all the time, we trust the people of Tennessee to make the right decisions. Our Constitution says that by giving us the right to worship no matter what mode we choose, as long as it's not infringing on someone else's rights, of course. And so I believe that the churches should have the right to make that decision themselves. Now, we're talking about something in the future, but we've got to remember, before this pandemic came around, 250 years ago when the First Amendment of the U.S. Constitution, 150 years ago when the Tennessee Constitution, as it is now, was passed, this was in the future. So all we're trying to do is address something today that could happen tomorrow, and we hope it never will.
Thank you.
You're up. So, you can do it on the bill, Gillespie. I think did you waive yours? You want to speak? Sure, you want
Thank you, Mr. Chairman. I just want to, my colleague from Shelby County just mentioned something, and I just want to make sure I'm clear about. In the language of this, public official, I'm Episcopalian. We have a bishop of West Tennessee that can make decisions like this. So she currently, during the pandemic, shut down all the Episcopal churches in the West Tennessee diocese. This has nothing, this would not put any type of restrictions on a public official such as that.
No, sir. You would have the freedom of religion to have church or not to have church as your denomination or church would decide.
Seeing no further, Representative Parkinson.
Thank you, Mr. Chair. And I just want to, you mentioned something, as long as it does not infringe on other people's rights, right? And so if in the middle, if we have a pandemic and there are church gatherings that are contributing to the spread of the virus, when these members, walk out of that space, or it causes a spreader event inside of churches, which we know factually has happened. Is that not an infringement on the rights of the people who do not have the virus? The possible contamination, possibly.
Well, it is my understanding that the bill has been amended to give the governor the option in the case of an infectious disease or rats or something like that, as you have said. So if there is an outbreak at a church, then I believe the governor or health official would have the right to say, hey, for the next however many weeks, no church. But if there's no outbreak in the church, then no one should have the right to come in and shut down the church and limit our mode of worship, the exercise of our religion, and our right to peaceably assemble.
Representative Parks.
And I'm, trust me, you're talking to the right one, because I'm all for, our individual rights and liberties.
I understand,
I promise you.
I appreciate that.
But I also, I also am concerned that if we strip the governor of his power, that I believe is constitutional in the state of Tennessee. Did we not give the governor his powers in our Tennessee Constitution? And maybe we can get legal to answer that, and maybe I'm wrong. I might be wrong. No? Okay. And so if we're stripping the governor of his powers to make that call, because let's say, for instance, if we're just like we had with the nursing homes in our state, and the call was because there were outbreaks, not in every nursing home, but in a lot of them. And in order to curb that outbreak, he had to make a call that, look, we're not going to have, people in and out of these nursing homes, and, we're going to get them vaccinated or tested and all these things. And we were able to stop, but we lost a lot of people lost a lot of loved ones in these nursing homes. And so, I just feel like if we, and I understand, and the part that you just explained that allows him to go church by church, but I can tell you in Shelby County, we got 600 churches stacked on each corner, right? And so I think that could become problematic when if there's a problem happening because of the gatherings inside of the churches, and it's happening in multiple churches across the state, for him to have to be able to cherry pick and say, okay, this church has to shut down, this church has to shut down, when you can make a decision and kill the spread possibly by pausing the services for a minute. Now, remember now, I don't believe that our governor, right now would do that. But my only concern is when we lock this into the code, there's absolutely nothing he can do. And so if you have a virus that spreads like wildfire through the churches, there's absolutely nothing that he can do.
Right. Yeah.
So that's my only concern.
Well, he would have the right with the amended version to shut down churches that are infected, is my understanding. And let me just, do I have the right to speak, Mr. Chairman? I'm sorry. Okay. I understand your thinking on that. But basically what you're saying, one bad apple means we have to throw out the whole bushel. And if that was your finger that was infected, you wouldn't cut off your head. that's what we're doing in California, New York, and several other states across the country right now. We're saying, hey, there's a potential that even though people go to Walmarts and Kroger's and they go buy cars and they go to restaurants and they eat out every day of the week, there's a potential that 1 or 2 days of the week they actually went to church, they might have caught the virus there. And so even though none of the other churches are affected, we're going to shut down all the churches because that one finger was infected, so let's just cut off the head and kill the whole thing.
Rose Park, we
And
need to
that is,
wrap this up.
yes, and so that, we don't believe that's the case. We don't believe you throw out the bushel or the baby with the bathwater.
And I agree with you. I agree with you. My only, where I part ways with you is, and I have 25 years of emergency services too, just
Thank
for the
you.
record.
Thank you.
Where I part ways is, we have to be able to have a strategy. The governor has to be able to have a strategy if he needs it. I don't think the governor would shut down churches in Tennessee, and we're not California.
Right.
And you know, but we don't have this problem right now, you know, and so, you know, this legislation to tie the hands of the governor concerns me when it's not an issue with our governor. It may be an issue in California. There's probably some great legislation for California, but, which I'm from California, but not here. And that's my only thing. And I appreciate, you know, your passion and everything for what you're saying.
So to keep from tying the hands of the governor, you want to give the governor the right to tie the hands of the church. And
Okay, I'm going to do a running debate here. I'm going to
Okay,
move on to Representative Garrett.
thank you, sir. Thank you.
Okay, you pass?
Yeah.
All right. No further questions. We're going to go back into session. Thank you,
Oh,
sir.
thank you, sir.
Yep, you're welcome. Question's been called on the bill as amended. We're looking to vote on sending 1137 to calendar and rules. All those in favor say aye. Those opposed? No. The ayes have it. So you move on to calendar and rules.
Thank you, Mr. Chairman and committee, and the debate.
It's not. Let's see here. Representative Akeem, this is item number 6, House Bill 723. Got a motion and a second. It's properly before us. Representative Akeem, you're recognized.
Thank you very much, Mr. Chair.
We have a motion and a second. You're
Oh,
recognized.
okay. Thank you very much, Mr. Chairman and members. What this bill does is requires the Department of Children's Services to publish the guidelines for best practices for identifying and reporting signs of child abuse, child sexual abuse, and human trafficking in which the victim is a child on the department's website. This bill was approved during our last session in 2020. It did not get through the Senate because of COVID, and I'll answer whatever questions you might have, sir.
Thank you, Representative. Members, do we have any questions? Seeing none? Oh, I'm sorry. Representative Garrett.
Representative, I'm sorry, I've just read the caption of your bill, and you want to publish the guidelines for best practices for identifying, reporting signs of child abuse. Is this in child sexual abuse and human trafficking? Is that right? Just you want to publish the guidelines to identify?
Yes.
What exactly are we identifying?
Okay.
Representative.
Okay, thank you very much, Mr. Chairman. What this would do is to provide to citizens, not just parents, a place where they can go to see what the guidelines and practices are, you know, if they suspect something, you know, as a direction, a way to go.
as to, and how to go about reporting, this type of activity.
Okay. Thank you very much for that clarification. I appreciate that.
Thank you. Representative Clemens?
Thank you, Mr. Chairman. I just wanted to, I think the summary makes it a little bit more convoluted than it is, where it just says, the actual bill just says the department shall publish the guidelines. I think if that was your question, that for identifying was added in the summary for some reason. The bill is much more straightforward. Thanks.
Any further questions? Questions been called. Without objection, we'll be voting on House Bill 723 to go to calendar and rules. All those in favor say aye. Aye. Those opposed? Ayes have it.
Thank you, Mr. Chairman. And
Yes, sir. Members, on to item number 7, House Bill 403 by Representative Carringer. We have a motion and a second. The bill is properly before us. Representative, you are recognized.
Thank you, Mr. Chairman, and thank you to all the committee members. I bring to you all House Bill 403 today to make a small change when the bill was passed back in 2019. In 2019, the General Assembly allowed current members to opt in through the Department of Health Vital Records to serve as officiants and solemnize marriages in Tennessee. This bill simply allows current and former members of the General Assembly who opted in during their time in service to serve as officiants and solemnize marriages. So what we're actually asking in House Bill 403 is to amend Section 1 Tennessee Code annotated Section 36-3-301, and it's to delete language as it is right now, members of the General Assembly, and substituting the language members and former members of the General Assembly. So just to really sum that up really easy is I was a Knox County Commissioner, and I can always marry people if I want to for as long as till I die. And so it was brought to our attention that we have some past state legislators who are no longer state legislators that were opted. You have to sign in with the Department of Health Vital Records right now as a legislator if you want to marry people. And so after you are no longer a state legislator, you cannot marry anyone. So we have some that while they were legislators apparently enjoyed marrying people, and they want to continue this process after they are no longer in legislation. So this is all that this bill is doing, is to allow those who want to opt in with the Department of Health Vital Records to marry, that after they're no longer a legislator, they could still perform these wonderful duties. So that is what House Bill 403 is, and I will now wait for questions. Thank you, Mr. Chairman.
As a former Metro Councilman myself, I also can do that for as long. And I've done about 10 or 11 marriages, and it's one of the most fun things that I do. Especially, and right now I'm 10-0. No one's been divorced, and I'm really, I'm like asking them. I'm like, don't break my record. Members, are there any questions? Representative Garrett.
Thank you, Mr. Chairman. We've just got what you, and I think this law was passed last year, but I couldn't remember. You may or may not know. But if you opt in, and for some reason you just don't like it, can you opt out? Or do you know? And it's fair enough if you don't know, because I probably should know that, but I just
You know, I don't know, but I'm sure that as our rights, you should be able to opt out, as you know, at any time, since that is, you know, something that you're agreeing to do. So.
Okay. Well, thank you. I just didn't know if you knew for sure. But
Well, thank you, Representative Garrett, for that. That's a very good question.
Thank you.
I think if you can opt in, you should be able to opt out. Representative Griffin.
Yeah, I did.
Thank you, Mr. Chairman. So do you have to opt in while you're serving, or this would allow you, even if you didn't opt in while you were serving, you can come back later and opt in?
The way that I understand it, the way that I understand it is, yes, you have to opt in by registering with the Department of Health Vital Records while you are currently a legislator. So those that had done that, this would allow them to continue to do it.
Representative?
Thank you for bringing the legislation. I don't really want to be in a position people want me to marry him and stuff necessarily. Anyway, so thank you very much.
All right, Chairman Farmer.
And thank you, Mr. Chairman. And Representative I'm sorry about that, Garrett. I'm not trying to throw insults, you know. Here. Sorry about that. Just looking, it says in, looks like section 2 of I-2, that says a former member of the General Assembly must have filed notice pursuant to subdivision I-1 or L1 while serving in the General Assembly. So that means you'd have to give your notice while you serve, and then you can continue to do so once your service is complete. So, for what that's worth.
Yep. Members, any further questions? Question been called. The objection will be voting on House Bill 403 to go to calendar and rules. All those in favor say aye. Those opposed? Ayes have it.
Thank you, Mr. Chairman, and I may be a little out of order, but can I say, my husband and I are getting ready to celebrate our 40th anniversary in August. If we renew our vows, I want to make sure that Representative Garrett right here is the minister. So is there any way of enforcing that?
Representative.
Or Griffith, yeah.
Representative, I want to remind you, I'm undefeated. So I mean, you may want to stick with what's good. Okay.
Thank you all so much. I appreciate it. Thank you.
Thank you, Representative. Members, we're going to item number 8, House Bill 1168 by Representative Harris. A motion and a second. The bill is properly before us. Representative Harris, you're recognized.
Thank you so much, Chairman, and to the entire committee for being so gracious in hearing this bill. I am very grateful to be able to do this part because it made it through subcommittee last week, and I was extremely happy about that. And so HB 1168 amends Tennessee Code Annotated Title 36. As it's introduced, it prohibits a court from solely considering a parent's disability to determine custody unless it impacts the parent's ability to meet the need of the child.
Good to know. Nothing to see here. Nothing to see here. So you may not.
I think it's part of the hazing phase. So.
It's what. Okay. All right.
All right, let's try this again. Thank you so much, Chairman, and to this entire committee for hearing this this bill. HB 1168, as introduced, prohibits a court from solely considering a parent's disability to determine custody unless it impacts the ability of the parent to meet the need of the child, and specifically that a court cannot consider a parent or guardian's disability alone in a termination of a parental right proceeding unless it impacts the physical or psychological welfare of the child. We all are aware of the Americans with Disability Act of 1990, which has been in law. It has been the law of the land for nearly a quarter of a century, and we expect to accommodate people with handicaps. We anticipate working side by side with disabled coworkers. We raise our families in the same neighborhoods and send our children to the same schools. But our courts do not always extend the same level of inclusiveness when it comes to granting child custody or visitation to a disabled parent. In fact, we are one of a few states that go above what the ADA mandates, and in current code, it states that the disability of a parent may be a factor to be considered in the court in awarding custody to another party. So this bill would just close up the loophole between what we currently do now versus what the ADA has. Although the ADA mandates equal access to the courts, once in state family court system, a parent's disability could be used by the other parent as a weapon for custody, visitation, or even as far as parental termination. A survey that was conducted showed that even in the last 2 years, over 100 complaints of possible disability discrimination by a Tennessee court were submitted for review. And the National Council on Disability published its concerns about the legal battles that disabled parents, many of whom are military veterans, encounter routinely in family court. The facts are the facts, and disabled parents who divorce are far more likely to lose custody of their children. Furthermore, most cognizant disabled mothers and fathers are likely to lose a custody challenge. This legislation is personal to me. I have a sister who was like a mother to me growing up. She's 15 years older than I am, and she went off to amazing colleges and universities and ended up working in some great careers. And a couple years ago, she fell ill all of a sudden from a health condition that was very, very rare, a brain condition that has caused somewhat of a disability for her as a parent. And she raises my young niece along with the help of my mother and my grandmother. And it would be very devastating to myself and my family if we were to have to go to court to fight for custody rights, all because of her disability. And so I also have a letter of support from the Tennessee Disability Coalition, support from the ARC of Tennessee. Had a conversation with the disability attorneys at the Disability Policy Alliance, and I hope that I can also let's go back I also had a conversation with our own attorney for this committee, and just making sure that we worked out some of the kinks with this one as well. And I hope that I can also gain the support of this committee on this legislation, and I yield back this time to the chair.
Well, thank you, Representative Harris. You've been getting tips from Representative Ramsey, I think, with being thorough with your with your explanations. But I do appreciate you're bringing some of the code into compliance with the ADA, and that's a good thing. Members, any questions? Representative Garrett.
Representative Harris, thank you for bringing this legislation. I should have read it before. It was the first time I've read it, and as a practicing lawyer that does some domestic work, some divorces and some custody battles, I'd be appalled if the other side tried to use as leverage a parent's disability against my particular parent. If I, of course, had the parent that was disabled, I think that would be an awful way to gain leverage in a custody matter, which it too often happens. Things like that people cannot control. They try to gain leverage over the other for not in the best interest of their children. So I appreciate this legislation. I think it's good legislation. So thank you very much for bringing it. I'm happy to vote for it. Thank you very much.
Any further questions? Seeing none, we'll be voting on House Bill 1168 to go to calendar and rules. All those in favor say aye. Aye. Those opposed? Ayes have it. Go to calendar and rules.
Chairman, if I could, I would also like to point out that this will actually be my first bill that possibly will be hitting the floor as a freshman.
Yeah, he did. Yeah, good job. Right. Members, we're on item number 9, House Bill 104, Representative Parkinson.
Thank you, Mr. Chair.
We have a motion and a second, and I believe you have an amendment.
Yes, sir. The amendment actually rewrites
I have a
the bill.
motion and a second on the amendments. It's tracking number 3691. Is that correct?
Yes, sir.
Representative, does the amendment make the bill?
It does, sir. Yes, sir.
Can we go ahead and put that on the bill then? Without objection, we will put the amendment on the bill. All those in favor of amendment number 1, say aye. Those opposed? Ayes have it. We're now on the bill as amended. Representative Parkinson, please explain.
Thank you, Mr. Chair, and thank you to the committee. What this bill does, it removes the 5-year statute of limitation for challenging voluntary acknowledgement of paternity. It also allows for non-custodial parents, if they want to go ahead and get a DNA test from an accredited testing lab that would make it admissible to the courts. And that's what the bill does.
Thank you for the explanation. Members, any questions? Chairman Farmer.
I do, and I noticed I should have spoke up before we voted on the amendment, because I noticed that this bill, with the amendment, it must have a fiscal note, because with the amendment it goes to finance, without amendment it didn't. So could you tell us what that amendment actually did?
Yes, sir. And so in the original bill, I was extending the amount of days that a person could remove rescind their signature on the birth certificate. And that ran into federal complications based on based on what the feds required. Okay. You need me to pause for a second?
Yeah, I think
I misspoke.
it was
With,
opposite.
with the amendment, it does not go to finance.
It removes the fiscal.
So it removed, you,
Yes.
so you cleared it up there. So that makes more
right.
sense. I was thinking, why
Yes,
would you, why would you amend your bill to do that? Okay, all right.
Okay.
I apologize. Thank
Good
you.
deal. Any further, Representative Griffey?
Thank you, Mr. Chairman. Thank you, Representative, for bringing it. Let me ask, is there an argument on the other side that maybe we should leave this statute of limitations in place for the benefit of the child and the adoptive parents or the parents, so that the kids have some certainty and they're not worried about sometime down the road, somebody's going to come in and reopen the case and involving them? So.
And thank you for that, Mr. Chair. And I'll tell you how we got here, why I'm even bringing this legislation. While in the barbershop, which I hadn't had a chance to get to in the last few weeks, as you probably can tell. And I see Representative Gillespie over there nodding his head, right? But and while I was in the barbershop getting a haircut, I had an individual that came to me, and he said, and I didn't know this, he didn't know me, but he knew I was a state rep, and he said he went to court because he found him and his girlfriend broke up. He got a DNA test on the child, found out that the child was not his, went to court to have the child support adjusted, and the magistrate or the judge who was over the hearing said, somebody's got to pay for him, and gavelled him out and said, you're responsible for him for the next 18 years, for the child for the next 18 years. And in that situation, the individual did not agree with the order, and when he didn't pay the child support, his license was suspended. When his license was suspended, he was pulled over, and he was put in jail for driving on a suspended license, and he lost his job. He lost his job, and his entire life, kind of went to the handbasket. And so, and I asked him, he said, I feel bad for the child. I do. He said, but it's not my child, right? And he said that child deserves to know exactly who his father really is. And what was happening was, in the law, it said that if, right now in the law, it says that you have up to 5 years to make that change. But here's the thing, here's reality. And some of you that practice family law, the reality is, it's so funny because we were doing town hall meetings, and I had juvenile court on the panels and everything, and they were saying, well, as soon as your baby is born, you need to go get a DNA test, right? Well, you kind of blanked if you do and blanked if you don't, because if you go get a DNA test, your relationship is through. If you go get a DNA test and you find out that the child is not yours, your relationship is through. And that's the reality of the matter. And so they happened to break up, but the child was, I think, 5 years and a month. And so he had just missed this cutoff. And it changed his entire life, because he lost his job and all this stuff. So that's why we're just giving more time for people to find out who the real father is.
And does it removes, what would be the new statute of limitations if it's not going to be 5 years, just indefinite?
There's no statute of limitations. If you find out that a child is not yours, you have the right to, that child has the right to know who his real father is, or her real father is.
I guess the statute would be 18 years.
I'm sorry, I can't support the legislation because I think that, children do need certainty in who's going to be the responsible parent. And I don't know all the specifics of that situation that came to you. And what I'm also worried about is people are together for a while, and then maybe the relationship deteriorates, and then this will become another weapon used in divorce proceedings or something. I respectfully don't feel like I can support it, so thank you.
President Parks, last follow-up.
Yes, sir, thank you. And just for the record, it does not deal with marriages. Marriages is not in this legislation. This is for people that are unwed. And the last thing is, we got to think about the perspective of that child also from a health standpoint. If that child does not know who he needs to find out who his real parents are in case that he needs to tap in from a health standpoint in latter years also. And thank you, Mr. Chair.
Yes.
And thank you for that, Representative.
Members, any further questions? We'll be voting on House Bill 104 to go to calendar and rules. All those in favor say aye. Aye. Those opposed? No. Clerk, call the roll. I can't determine who's.
Representatives Bricken, Clemens, Curcio, Eldridge, Farmer, Garrett, Gillespie, Griffey, Harris, Littleton, Ogles, Parkinson, Ramsey, Smith, Stewart, Vice Chairman Jernigan,
Aye.
Chairman Carter. Mr. Vice Chairman, you have Mr. Vice Chairman, you have 6 ayes and 7 noes.
Representative Parkinson, the bill fails.
Thank you, Mr. Chair. Thank you, committee.
Sir. Going to item number 10, which is House Bill 200 by Representative Carter. I got a motion and a second. I believe Chairman Littleton will be carrying this bill. Chairman Littleton, you're recognized.
Thank you, Chairman. I feel honored to carry Judge Carter's adoption bill. I know they've worked really hard on this, and it's going to do a whole lot for the children and the adoption of children in the state of Tennessee. So this bill, the legislation incorporates trends in child welfare laws since the enactment of the current best interest legislation in 1996. It would clarify the courts have the discretion to apply only the best interest factors that apply to the particular case, would reiterate the courts are not limited to consider only the factors listed in the legislation, and reworks and expands factors so as to better assist courts in the best interest and analysis.
Thank you, Chair Lady. I need a motion and a second on this bill. Got a motion and a second. It's probably before us. Thank you for the description. Members, any questions? Seeing none, we'll be voting on House Bill 200 to go to calendar and rules. All those in favor say aye. Those opposed? Ayes have it.
Thank you.
Members, that completes our calendar. Any announcements before we adjourn? All right, so moved. Motion to adjourn. We're out.